and welcome to today's webinar, Avoiding Residential Lease Traps, Some Tips and Techniques. My name is Stephen Smith. I'm the Country Manager at Stewart Title Limited, and I'm delighted to be joined once again for the second series in this link of webinars we're doing by Ian Quayle, who will be leading today's session.
Morning.
Good morning, Ian. I think you will be familiar with Ian by now, a qualified solicitor. Through his business, IQ Legal Training, Ian has delivered over 1,500 training courses, all property related, for city and regional firms, local law societies and local authorities. Ian, good morning and welcome. You're quite busy at the moment, you were saying. So.
Yeah, very busy, Steve. Yeah, incredibly busy with mainly sort of webinars, obviously, and then delegates sort of raising and generating questions, which I like, to be honest with you, on the basis that it gives you something to think about, and it's interesting to see where the profession is going with, issues that are sort of live and relevant to the current environment, and also sort of general day-to-day sort of conveyancing questions. And I gather you're busy too, Steve, from what you were saying a little earlier.
It's definitely starting to pick up for sure,
Yeah.
but we'll see whether that's a long-term trend or not. Obviously, it's a very uncertain time. But,
Absolutely.
Yeah, we will see. Absolutely. Just before I hand over, I'll just go through some of the audio paying for the audience here. So, as you're probably familiar now, you're listening through your speakers by default on your computer. You can listen through the telephone. There is a toll-free option, which I have checked and is completely free. There's no network charge as far as I can see. So if you would prefer to listen to over your telephone, you can click the telephone option and the dial-in information will be displayed. As is always the case, you will have the opportunity to submit text questions to Ian by typing your questions in the questions pane of the control panel. You may also send your questions at any time during the presentation, but we will have a dedicated Q&A at the end of today's presentation. As is always the case, you can always raise your hand as well if you want. Basically, this is very similar to asking a question, but if we see the raised hands, we'll assume that you want to speak over your speakers and ask the question directly to Ian, and I can unmute your speakers in order to do that, or your microphone, I should say. You'll hopefully see that we've added today's notes to the handout section. That should be part of your control panel, so there should be a handout there towards the bottom of it. To access the handout is quite straightforward. You just click on the PDF button. It will automatically start downloading to your default web browser. It should be on the bottom left-hand side of your screen as it starts to download, and then from there you can either click to open it or to save it if you wish, or both, of course. And hopefully you'll be able to follow the notes and the session through there. I've also just actually put a link in the chat section. If there is anyone having audio problems, we do our best to try and resolve those remotely, but there is a kind of an FAQ and a troubleshooting audio section in that link if anyone wants to check that. I will be running a poll at the end of today's session, which would be great to keep you all engaged. So I will give details of that a bit later on. But without further ado, I'll pass on to Ian for the main part of the presentation. All yours, Ian.
Thank you, Stephen. Good morning, everyone, and it's nice to be with you again. Series 2. Delighted to be joining you for yet more training. Before we start, again, a big thank you to Stephen and Robert and Stewart Title for organising these events. I'm astounded as to the number of delegates that listen in to these events. It's really impressive, and of course, down to the organisational skills of Stewart Title. What we're going to be doing today is looking at a number of issues relating to residential leases. I could spend a week talking about problems and issues associated with residential leasehold conveyancing. We are in the later webinars going to be looking at issues related to ground rents, and we're also going to be talking about estate rent charges, etc. So I'm sort of skirting around those issues today on the basis that I don't want to steal my thunder for the future. As Stephen mentioned, happy to take questions at any stage as we progress. and you will have my email address, and you've got Stephen's contact details too. So feel free, if you have any questions or issues or require amplification or clarification as to any of the points I make, drop me a note by email, and endeavour to assist. Again, I've been really impressed with the questions that have been asked and the sort of the communication from delegates. It's very enlightening to see questions, issues, and some of the comments that have been posted. So without further ado, let's sort of have a look at what we're going to be talking about relating to residential leases. First point is quite simply points that you've heard me mention before, but in the context of leasehold conveyancing, well worth repeating. First point, remember the SRA thematic review when we talked about lockdown, and I mentioned we expect all firms to clearly report in writing to clients on whether a property is offered on a freehold or leasehold basis. Essential that you advise clients as to the distinction between freehold and leasehold. Absolutely essential, if you look at the Legal Ombudsman's website, that we understand and appreciate what causes problems or issues. And I mentioned in the notes an old Legal Ombudsman's report called Losing the Plot, in which there was reference to some particular scenarios that were reported to the Ombudsman. A client losing £25,000 of the value of the leasehold property because there was a failure to provide adequate advice regarding details on leasehold. Key word there is adequate advice. It is not enough to provide a client with a copy of the lease. We've got to be doing more than that. And remember what we said in connection with that thematic review, we've got to deal with the basics. Just what is the difference between a freehold and leasehold transaction? What disadvantage are you put to if you are acquiring a leasehold property? The next point that, again, I mention is a problem that is frequently encountered with leasehold transactions, again taken from the old Legal Ombudsman's report, concerning a lady called Miss F, who buys an apartment and discovers at a later date that what she thought was she was acquiring did not include a converted attic room. And the lease was at odds with the sales particulars, and again, there was an issue with regard to her conveyancer. So those two cases, and the Legal Ombudsman's site, to be honest with you, is quite useful to get a flavour of what causes claims and what causes complaints in the context of leasehold, as well as residential conveyancing generally. I mentioned on the slide the terrible truth about clients. Has anyone read the book The Terrible Truth About Lawyers, written by a guy who's dead now called Mark McCormack, who was a lawyer in the States and who created, I think it's the IMG Group, International Sports Marketing or something, it was a big business. Anyway, he wrote a book called The Terrible Truth About Lawyers. One day I keep threatening to write a book about the terrible truth about clients, on the basis that I've got plenty of stories to tell about how forgetful clients are, how good they are at spotting some things and bad they are at others. It is astounding as to how few clients actually read their lease and understand the advice that they're given relating to it. I've acted over the years for a number of what I would call quite nasty landlords who will buy freehold reversions and then extract as much money as is possible from leaseholders using various methods, some of which I approve of and the vast majority of which I don't. Again, the reason that they're able to do that, the reason they're able to feed off unfortunate leaseholders, is the fact that those unfortunate leaseholders either were not advised properly when they acquired the leasehold property, or were advised properly but have forgotten or haven't considered the advice that was given. Important that we tell the clients the basics in a manner that the client can understand. And in doing that, in the notes, I mentioned two useful external sources, both of which I've mentioned to you before, and one which I've touched on but not really mentioned in any depth. Leasehold Advisory Service website we know about. The guidance about understanding your lease I've referred to, as I've also mentioned the online quiz. Have a look at it. It is useful. It provides background to the client free of charge, that is written in a sort of consumer-friendly way that I'm sure your clients may be able to digest and understand. The Association of Residential Managing Agents, or ARMA, has other guidance called Living in Leasehold Flats. which again is useful. The Leasehold Knowledge Partnership, which I've mentioned to you in the past, has advice guides. These are rather confrontational. They're quite aggressive, really, as to, let's go to tribunal as quick as we can, seems to be the stance. But again, useful information for leaseholders, giving them a flavour of the potential problems that leasehold ownership generates. So we've got to provide clients with the sort of background with regard to the distinction between freehold and leasehold ownership. We've also got to explain the particulars about the key terms of a lease. Remember, it's not enough to give a client a copy of the lease. The client should be given a copy of the lease and an explanation of the lease terms. I've argued with professional indemnity insurers over the years who have said to me, well, all right, you've sent a lease, you've sent an explanation to the client, but how do you know the client's read it? How do you know the client's understood it? Some firms will ask the client to sign a copy of the report on title or letter of advice, sign a copy of the lease, or acknowledge safe receipt of the document. It's important that we do something so that if at a later date the client said, well, I didn't get it, or I did get it, but I didn't understand it, you've got some proof on file to say, well, hang on a minute, I explained it to you, and I asked you to confirm that you understood, that you read it and understood it, and I asked you if you had any questions, and you didn't come back to me on any of those points. So this idea about making sure you've got evidence on file that the client understands the obligations that the lease generates is significant. Don't be frightened about asking clients to sign attendance notes. Don't be frightened about making a note of a telephone call and then emailing it to the client and saying to the client, this is a note of our recent conversation. I'll assume you agree that it's an accurate note of what was said unless you let me know to the contrary. The next point really to make is problem clauses in residential leases. And I've touched on this in connection with that old example from the legal ombudsman, identifying the demise. But it's more than that, isn't it? It's identifying the premises, the structure, the common parts. When we look at a lease, we should be able to look at a building and say to ourselves, we can identify each and every part of that building from the description within the lease itself. So it should identify the demise clearly. If there's reference to a lease plan, the plan and description should be consistent with one another. There was an interesting High Court decision 2 years ago where a judge said, I'm looking at a lease and I'm looking at a lease plan. The lease description of the demise says it's more particularly delineated or defined by reference to the plan. But there's a dispute because there's an inconsistency between the plan and the description. And the judge said, what I'm going to do is attach no weight to the fact that the description says the plan prevails. What I'm going to do is have a look at photographs of the demise and see which of the two makes most sense given what I see in situ. So that's important. There needs to be consistency between description and plan. And as I've mentioned to you already, I would always provide the client with a plan, lease plan, but also with a description of the demise as well, and say to the client, can you clearly identify the demise from these two pieces of information? Are they consistent with one another, and are they consistent with what you see? And of course, if there's a title plan, we can throw that into the mix with the health warning we discussed in a previous webinar. I want to be able to identify structure, not just see reference in the lease to structure or common parts. I mentioned I've acted for some funny landlords over the year. One landlord in particular, in the last recession, did an audit of all his freehold reversions and identified a development in Greater London and identified that the lease did not specify what the common parts were. And the building, a block of flats, had a rather large sort of entrance hall with lifts and caretaker's office and various things. And the client decided to divide that area into two and create, in essence, some retail space, which he then let to a restaurant chain. The leaseholders were up in arms about this on the basis that, what was a relatively grand entrance had suddenly been reduced to half the size. There was no definition of common parts. Leaseholders had rights of access and egress, but were still entitled to have rights of access and egress over the remaining areas, and were reluctant to litigate on the basis that it was quite clear from the lease that it was impossible to determine just what the common parts were. Identification of demise, building, premises, structure, common parts become critical when we start talking about repairing obligations. Where we're getting a survey or valuation, and we should always be obtaining a survey or valuation, it is important to see what the surveyor or valuer has to say about the extent of the demise. To that end, if we're given the opportunity, I'd always like a surveyor or valuer to see a copy of the lease and to refer the surveyor or valuer within their survey or valuation report, confirm whether the description of the demise or lease plan appears to be satisfactory and accord with what was seen on inspection or survey. The next point is, as far as lease plans are concerned, lease plans can cause problems on the basis that they're not Practice Guide 40 compliant. Be wary of registering unregistered leases on the basis that the land registry are likely to requisition on the basis that the plan is not Practice Guide 40 compliant. With leasehold flats, be careful that the lease plan is sufficiently detailed to enable the demise to be clearly identifiable. The land registry seem to get themselves in knots with regard to buildings where there's complex sort of floor plans or floor levels, etc. So again, it's important to produce a plan that enables the demise, a floor plan to enable the demise to be identified, but it might be also appropriate to provide a drawing or specification that shows just where this floor level is in connection with the building. So identification of demise, building, structure, common parts, important. Lease plan, important. The next thing I talk about is parking rights. And the reason I mention this, I've seen lots of complaints from clients about firms failing to advise them properly with regard to car parking, and I've also seen negligence claims, and I've also seen some nasty tricks from nasty landlords. The worst trick I've seen with regard to car parking was where car parking was dealt with within management regulations. So the lease referred to the fact that leaseholders had the right to compete for car parking spaces in accordance with management regulations. And what the landlord did is he sold an area of the car park. And his idea in doing so was that the management regulations and the lease simply stated that there was a right to compete for car parking spaces. Originally, there was more than sufficient car parking for each flat owner to have their own car parking space, but all he did was increase competition by reducing the size of the car park and reducing the number of bays by 20. Perfectly entitled to do so. You can alter management regulations. Remember what I've said previously, as long as it's in the best interest of the leaseholders generally. What the landlord did was consult with the leaseholders and said to them, if I sell an area of land that equates to 20 car parking spaces, I'm going to increase the competition for those spaces, but what I'm prepared to do is utilize some of the money that I'm going to receive to reduce your service charge for the next 3 years. And he got the majority of leaseholders saying that they were willing to proceed on that basis. The car parking was not part of the demise. It wasn't an easement. It was dealt with by way of regulation. Regulations, as I've mentioned to you already, can be and are frequently altered. If I was asked what is best with regard to car parking, the car parking space being included as part of the demise is the best possible scenario. If that is the case, then again, the point that I made a little earlier about making sure the demise is clearly identifiable is critical. Again, from land registry data and from complaint data that I've seen over the years, frequently car parking areas, independent areas of garden that are part of the demise are frequently excluded from plans that can create problems or issues at a later date. Car parking as an easement is a neat way of dealing with car parking these days and perfectly acceptable. Do make sure that the car parking right is referred to as an easement, is included in the schedule of easements in the lease, and is included as LR11 of the prescribed clauses. From a landlord's perspective, from a draftsman's perspective, if you are dealing with car parking as an easement, make sure the landlord retains a degree of control over the car parking spaces. So he repairs and maintains the car parking spaces. He reserves the right to allocate alternative bays within the car park so he can switch leaseholders around, and he retains development rights over the car parking areas. All of those would be an indicator that the landlord has retained sufficient rights for the right to park to be an easement. Where you're granting exclusivity, repair and maintenance rights to the leaseholder, then the argument is that you are doing more than granting an easement, and therefore an easement is not being properly created. So do watch out for that. And the worst case scenario with regard to car parking, as I've mentioned a little earlier, is the fact that car parking is dealt with by way of management regulations. So car parking should be part of the demise. It should alternatively be an easement, provided that it is an easement, provided the landlord is retaining sufficient control over the car parking areas. Watch where you are granting exclusivity to a leaseholder. The idea there is that that potentially is not an easement. And do watch out for situations where landlords let car parking out on the basis that it is possible for a 54 Act lease to arise with regard to exclusivity being given to car parking for business purposes. I dealt with the negligence claims concerning a car park where the residential car park was let in part to a firm of lawyers, and they were allocated specific bays, and the bays had the name of the firm on them, and the court's attitude was that because a fee was being paid, in essence that fee was a rent, and the occupation amounted to a 54 Act protected tenancy, which caused a number of problems at a later date. The issue of repair I mentioned. The lease should allocate responsibility for repair with regard to various parts of the premises. And we're back to this issue about plans or property description again. Important, the lease should specify the extent of the demise and should specify that the leaseholder is required to effect repair. So one, we need to know the physical extent of the repair, then we need to know the legal extent of the repair. What does the repairing obligation impose? I don't like any lease that requires a leaseholder to do anything over and above keeping in repair. So alarm bells ring if there's a requirement to renew or improve. Alarm bells ring where there's reference to repair and condition. The addition of the words and condition imposes an additional obligation on the leaseholder, which potentially can be onerous. The courts are reluctant to imply repairing obligations on leaseholders. They are potentially more willing to impose repairing obligations on a landlord with regard to common parts and structure. But I've given you Duke of Westminster against Guild, which is an old case, 84 case, but the court said where there is no express covenant, a landlord is under no obligation to repair. Watch voids where no one is obliged to repair, or watch overlap. Two horror stories to tell you about. A block of flats in London, Greater London, not Central London, with concrete balconies. The balconies weren't described as part of the demise, although each leaseholder had exclusive use, nor were they referred to as structure. The balconies were made out of concrete, and there was a defect with regard to the mix that meant the balconies became dangerous. Leaseholders wrote to landlord and said, structure, your responsibility, will you repair? Landlord says, no, not structure. One leaseholder reported the disrepair and the danger to the local authority, to the relevant borough's building control department, arguing under the Housing Act that the local authority, Royal Borough, was under an obligation to ensure housing stock within the borough was kept safe, and this was a potential breach. The local authority, the Royal Borough in this particular case, served a hazard awareness notice requiring attention to these defective balconies. You'd imagine it would be served on the landlord. In fact, it was served on the leaseholders. The Housing Act does permit that. So with regard to disrepair or with regard to danger, the Housing Act does entitle notice to be served on landlord or leaseholder. So in this particular case, the leaseholder shot himself in the foot. Had the notice been served on the landlord could have effected repair, but because of repair being undertaken as a consequence of statutory notice, would have been able to transmit cost into service charge. Remember, we said about survey and valuation. Again, I've highlighted the need to look at the RICS consumer guide to survey and valuation and it should be provided to clients. In a leasehold context, the client should always be advised of the need for a full structural survey of the property that's being acquired, of the demise and the building, on the basis that there could be repairing obligations or repairing issues relevant to defects to common parts or structure that could impact on your leaseholder client's use and enjoyment of the building, or could lead to an increase in service charge. Remember that we should be looking not only at what the leaseholder has to repair, but also what the landlord has to repair. And if the landlord enters into a covenant to repair, an important point, can he transmit the cost into service charge? I got an email last year, and I had another one about 2 years previous, where a lawyer emailed me and said, can you just have a look at this? Because I think my client is getting a bargain. We're buying a leasehold flat, landlord obliged to repair structure and common parts, but no provision for transmission into service charge for the cost that the landlord incurs. So the advice from the lawyer was, this is a good lease for the leaseholder to enter into. My advice is that it's a bad lease. Why? Why would a landlord effect repair to part of the property if he can't transmit cost? The only way he's going to be committed to carry out repair is if he's bounced into litigation via county court or tribunal to comply with the covenant to repair. And that's going to involve leaseholders in cost and expense. But landlords, generally speaking, are going to be quite dilatory in connection with meeting the repairs when the cost of repair can't be transmitted. It is possible to seek application under the 1987 Act, Landlord and Tenant Act 1987, to vary a defective lease in those circumstances. But again, that's going to be cumbersome and time consuming. My stance is it is a bad lease where a landlord is obliged to effect repair but can't transmit cost. Where a landlord enters into a concurrent lease with a management company or anything of that nature, do check to make sure that if anything happens to that management company, the obligations under the lease then revert back to the original landlord. So we're not left high and dry with regard to a repairing obligation that the landlord is unable or unwilling to comply with. So always check out repair. Remember client's obligation to inspect and to highlight anything that is seen during inspection. I mentioned in the notes a number of points relating to user. And I'm going to talk about some Airbnb issues a little later in my presentation today, which highlights the potential issue relating to use. The point I would emphasize is this: we should always be identifying buyer objective on acquisition of a freehold or leasehold property. If we're buying a leasehold property, does the objective sit comfortably with the user clause? So I'm buying this flat, I'm intent on working from home. Well, would a flat with a covenant that says the flat can only be used as a private residence fit the client objective? Probably not. What's the position if the client is going to buy the flat, but the son is going to live in the flat with two former university colleagues who are going to be paying board and lodging for the accommodation? Well, in those circumstances, that's not a private residence. If our client intends to let the property for Airbnb purposes, again, that is not a private residence and would constitute a breach of covenant. So user clauses need to be checked. Watch mixed-use buildings. You sometimes see them in London. Watch provisions that enable a landlord to give consent with regard to change of use. Again, how's that going to impact on your client's position? Generally speaking, important to understand that if a lease contains a qualified covenant requiring landlord's consent to change of use, no statutory implication that such consent can't be unreasonably withheld. But remember section 19.3 of the Landlord and Tenant Act 27, that where there's a qualified user covenant, implied proviso that the change of user doesn't involve any structural alteration of the premises. In those circumstances, the landlord can require a payment of a reasonable sum in respect of damage or diminution in the value of the premises where the change of use does involve structural alteration of the premises. We can, in those circumstances, as a landlord, recover cost. So always watch user covenant, always check it's consistent with client's objective. Other covenants that can link to user, obviously the covenant with regard to legal or immoral purposes, causing nuisance or annoyance to owners, tenants, and occupants. Interesting point, most nuisance covenants in residential leases will mean that the leaseholder is likely to be hit for costs associated with contamination and decontamination. So if a block of flats is on land that is subject to contamination, the Environment Agency can pursue the landlord as well as the current leaseholders. But where the Environment Agency pursue the landlord, the likelihood is that the landlord will transmit the cost into service charge, either because the notice from the Environment Agency is a statutory notice, or on the basis that the decontamination and costs associated fall within nuisance covenants. Another point, really, just as an aside there, be careful with regard to environmental issues in connection with flats. Just because your client is buying a fifth floor apartment in a block does not mean it could be liable for decontamination issues in connection with previous use. Remember, with regard to contamination, the original polluter, the owner or occupant of land, time of pollution, subsequent owners or subsequent occupants can be liable for decontamination cost. I also mentioned in the notes planning issues and building regulation consents and approvals, covenants relating to superior title, again important, because you might say, well, all right, Ian, the superior title contains a covenant that precludes residential development, but the landlord has built and developed the block of flats in breach of that covenant. So if the original landlord comes along and says you're in breach and stop what you're doing, then I've got a derogation from grant claim against my landlord. Well, that's going to stand you in an awful lot of good stead, isn't it, when you're at risk of losing your flat or apartment. In addition to that, with regard to derogation from grant claims or quiet enjoyment claims, in essence, you're going to be entitled to damages, but nothing more. And that assumes that the damages are going to be recoverable from a landlord. I've acted on a number of occasions in connection with leaseholder actions against landlords that have been successful, and the landlord then has simply had gone into administration or gone into liquidation, and it's been a Pyrrhic victory. I mentioned alterations at the bottom of the slide. A lease should have flexibility with regard to alterations. Let me explain what I mean. If your client is intent on undertaking significant alterations that have an impact on the external appearance of the building or are structural, then it's perfectly proper for a landlord to impose quite a harsh regime relating to landlord's consent. So, landlord insists that drawings and specifications are submitted to the landlord first. That if a planning application is submitted, the landlord sees that application and approves it before it goes in. Landlord then appoints someone, architect or agent, to inspect the works as they're done, and then signs them off on the basis that the works that had been done comply with the original specifications, drawings, etc., that was submitted to the landlord and when conditional approval was first granted. Fantastic. Okay. What's the position, however, if your client wants to knock the wall down between the toilet and the bathroom? It's a partition wall. I had this in Liverpool with regard to a firm of lawyers that asked me what was the position. You had a very onerous regime in the lease that had all those stages that I mentioned earlier. Drawings and specifications sent to landlord for initial approval. Initial approval granted subject to supervision. On completion of the works, supervision re-inspects and confirms that works have been done meet the original specification and conditional consent. So the leaseholder's costs for taking down this partition wall, £200 plus VAT. Landlord's charges for consent, £2,500. Why? Because the lease contained a ridiculously onerous regime relating to alterations. Some practical points relating to alterations. If you're acting for a buyer who tells you that he's intent on carrying out alterations after acquisition, your job is to tell the client what the lease says with regard to the mechanisms for landlord's consent, but I would limit the scope of my retainer so that I'm not giving any advice relating to those works or any issues relating to construction, planning or building regulation, consents and approvals. Next point, practical point, it's frequently the case that a leaseholder gets carried away when he's got builders in relating to alterations. So you may see a landlord consenting conditionally upon certain works that are being done, but then the leaseholder gets carried away with themselves and does additional works while the builders are still there, for which consent has not been obtained. Watch when acquiring leasehold property to see if there have been alterations or works done, that the works meet the consent that the landlord provided. And watch the issue of retrospective consent for alterations. I have seen landlords turn around and say, in a connection with a leasehold house where a conservatory was built without landlord's consent, I want £15,000 for retrospective consent. It didn't help that the request for retrospective consent was made after exchange of contract. It didn't help that the landlord was aware that the buyer was likely to withdraw if the consent wasn't available. Remember what I've said to you in the past, the landlord can only charge a reasonable fee by way of administration charge. A fee for retrospective consent is an administration charge, and the landlord must therefore ask, one, what damage is there to the residual value of my reversionary interest as a consequence of the works that have been done? And secondly, what complaints, issues or work have I had to do with regard to the works that have been done? In other words, have there been complaints from neighbours, etc.? If there hasn't, then the fee for retrospective consent should be relatively nominal. If the landlord has to instruct solicitors to deal with retrospective consent, then if that charge is a reasonable charge for the legal work that's done, that is recoverable. But a landlord can't say, I could forfeit the lease, I could make you take the conservatory down, and therefore I want the value of the conservatory as my fee for retrospective consent. He's not entitled to do that. I mentioned in the notes issues relating to alterations. If an alteration amounts to an improvement, then if a landlord's consent is required, it cannot be unreasonably withheld. I've given you details with regard to that. And I've also mentioned that as far as consents are concerned relating to alterations, it is imperative that someone checks that the consent actually relates to the work that was actually done. Shows you how sad I am, really, doesn't it? I'm really interested in service charges and residential leases. When people say what sort of areas of law really interest me, it really does sort of worry me sometimes. So yes, service charge, one of my sort of pet subjects and one of my pet sort of areas of law that I spend a lot of time researching. There are some key points relative to service charge that I want to share with you. One, a residential lease should have a service charge regime that requires estimated accounts to be produced at the beginning of the year, final accounts produced at the end of the year, with some form of opportunity for leaseholder challenge in connection with final accounts, but a point after which no challenge is available. It is imperative that there should be some form of ADR, some form of dispute resolution provision within the lease dealing with service charge disputes. Point number one. Point number two, the service charge regime should be consistent with the Common Hold and Leasehold Reform Act 2002 and the obligation on the landlord to consult with regard to various works of various values. Important point with regard to this, the consultation obligation is quite a severe regime that's imposed on the landlord. And if a landlord fails to comply with that regime at all, then the amount of service charge that is recoverable relevant to those works is fixed at £200 or £250, depending on the nature of the works. So if a landlord fails to comply with the process, he's got a problem on his hands. Residential Property Tribunal has jurisdiction to waive or suspend the need to comply with the duty to consult. That jurisdiction will only be exercised if it's in the best interest of leaseholders. Therefore, a landlord who hasn't gone through the process, realizes he hasn't gone through the process, realizes he's incurred an expense that is now irrecoverable, is going to get fairly short change out of a tribunal application. tribunal is likely to say the consultation system is there to protect leaseholders, and therefore you haven't complied with that system, you've had it. If a landlord tries to comply with the process, but there's some form of minor error with regard to the process, then the tribunal may waive that irregularity. The best thing for a landlord to do is to make application to suspend the need to consult before he or she does the works. But the point I want to emphasize, the lease should be consistent with the Common Hold and Leasehold Reform Act 2002 consultation obligations. Another point, not in the notes, not on slide, I just thought about, watch mixed use schemes. If you've got a commercial element and a residential element, the two don't mix with regard to service charge. You should have two separate regimes with common costs. The lease should contain duality. By that I mean the lease should specify the services that the landlord provides and allow the landlord to transmit the cost of the provision of those services into service charge. The lease should also deal with unusual items of expenditure, either by way of allowing the landlord to borrow money and to charge interest into service charge, or to create a reserve or sinking fund. Important point, if there is a reserve or sinking fund in a residential lease, limit the scope of your retainer. You can't tell a client whether a reserve or sinking fund is good, bad, or indifferent. All you can tell the client is that the lease requires a service charge fund and a service charge fund exists. Common Hold and Leasehold Reform Act, as drafted, required a landlord to put a service charge, reserve or sinking fund into a separate bank account. And there should be a separate bank account for each fund for each development. That part of the act is still not good law, still not enacted. So all a landlord has to do is to have one reserve or sinking fund, and that can apply to all his or her developments or all his or her reversionary interests. I like landlords to be able to borrow money and transmit cost into service charge, or create reserve or sinking funds. Why? Because if he doesn't, and we're all leaseholders in a block of flats, and the block of flats needs a new roof or needs lift replacing, etc., we're going to be hit with an extraordinary service charge for the current year. And yet we're not likely to derive all the benefits from that cost. And in addition, the landlord is going to have an additional hurdle of going through the consultation process. Better, in my view, to utilise the reserve or sinking fund for the outlay, or for the landlord to borrow money, say over 10 years, and spread the cost. Unusual items of expenditure, reserve or sinking funds, cannot be utilised for any purpose other than unusual items of expenditure. So just because a number of leaseholders in the current economic climate have been unable to pay their service charge for the current quarter does not entitle a landlord to dip into the reserve or sinking fund to meet the shortfall. I mentioned on slide 3-year service charge accounts, and I often laugh in conveyancing transactions when the seller sort of dutifully produces 3-year service charge accounts in the contract bundle. Because what as a conveyancer am I supposed to do with them? Am I supposed to take them home with me at night and sort of scrutinize them carefully to see whether the accounts are good or bad? Am I required to note current accountancy processes and procedures? Well, clearly not. What can I do? I can look at the lease and see what services the lease requires the landlord to provide, and then look at the 3-year service charge accounts to see if they are indeed what the landlord has incurred and has paid for. I can also look at trends to say, well, yeah, year on year, the service charge is about the same. But that's all I can do. I would always suggest that accountancy advice is required, particularly where the service charge accounts are extensive and the service charge a significant amount of money. And I'd always warn a client that just because I've got data with regard to historical service charge is not an indicator as to what service charge would be in the future. Service charge clauses are drafted so that the services are specified within the lease. Not just the services, but the extent of the services. So I want detail. And the lease should specify that costs can be reimbursed. A number of problem areas with regard to service charge. Sweeping up provisions. The courts don't like them, to be honest with you, and I can show you cases where sweeping up clauses have been deemed to be unenforceable. What you can do is have a sweeping up provision and then a list of the sorts of costs that are being envisaged. The same sort of principle applies with legal costs. Simply to state in a lease that any legal costs associated with management are recoverable, in my view, is not sufficient. There should be an attempt to identify the sorts of costs that are envisaged. What's the landlord required to service? So again, that goes back to my first point this morning about what's the extent of the common parts or structure. What repairing obligations is the landlord obliged to attend to? Is the landlord entitled to carry out improvements? Well, this is a danger area, because if the service charge management fee is based on a percentage of service charge cost, and if I as a landlord can not only repair but improve, there's a likelihood I'm going to increase the service charge cost and thus increase management fee. So surely there's an incentive in such circumstances for me, rather than carry out relatively inexpensive repairs, to carry out expensive improvements, hiking up management fees. Which leads me on to the point, I don't like management fees that are a percentage of service charge cost, because there's an incentive there for a landlord to rack up cost to increase fees. On that note, I've dealt with an interesting thing recently in Manchester, where a lease enabled a landlord to appoint a managing agent and to include managing agent's cost into service charge, and to charge a management fee of 20% of service charge cost. So in other words, he's entitled to a management fee for managing the manager, which is quite an interesting thing. Why on earth anyone would agree to such provisions in a lease, I don't know, but that's what the lease says. Watch out for service charge on unsold or unlet units. Why? In some leases, the landlord is not liable for the costs, but the costs are transmitted to sold or let units. So I dealt with a negligence claim in connection with a development in Leeds, 25 units, 5 sold. The remaining 20 could not be sold, downturn in market. The buyers, the owners of the 5 flats, were left with meeting the service charge cost of the entire development. The lease should have said that the landlord was liable for the costs accruing to unsold units. I mentioned in the notes all sorts of issues relating to service charge. You can have a look at it. There are 1 or 2 points that I want to draw out if I can. Watch how service charge is apportioned. Watch how service charge is paid. If at the end of the year there's a shortfall, is there a reasonable time to enable leaseholders to meet that shortfall? I think it's particularly unfair that service charge years often end at the end of December, and that if there's a shortfall, leaseholders are required to meet the shortfall within 14 days. A good lease would state that the shortfall is then transmitted into the next year's service charge and paid monthly in advance, as with the future service charge payments. Watch where a landlord is taken to tribunal and loses or doesn't recover costs. I mentioned the fact that the landlord can try and sneak in the costs that are incurred into future service charge. I dealt with a block of flats where there was one particular leaseholder that was a sort of barrack room lawyer, and he took great delight in taking the landlord to tribunal all the time. And every time he did, he lost. And every time we got an order for costs against him. And every time he was unable to pay, so we transmitted the cost into service charge. You can insist on application to tribunal that any costs that are incurred relating to that tribunal hearing or that tribunal application cannot be transmitted into service charge cost in that manner. I mentioned some key points with regard to service charge that I'd like to draw to your attention. Firstly, the 18-month rule. Significant rule, this section 20B, Landlord and Tenant Act 1985. If a landlord incurs a cost but doesn't transmit service charge accounts or doesn't notify leaseholders that the cost has been incurred, he loses the right to recover that cost after 18 months. A case called Gilge against Charlegrove deals with that issue. Secondly, and significantly, and again, a number of practitioners are not aware of this point, Section 153, Common Home Leasehold Reform Act, a demand for payment of service charge must be accompanied by a summary of rights relating to service charge. In other words, the right to challenge, etc. If you don't provide that, then you can't recover the service charge. And then finally, the point that I made with regard to tribunal costs, Section 20C, Landlord and Tenant Act 1985. In those circumstances, the costs that are incurred in the tribunal cannot be recovered by way of service charge against further leaseholders. And now I want to talk about claims avoidance, but before I do that, Robert Kelly is with us from Stewart Title. And Robert, I wanted to talk to you about the availability of indemnity insurance relating to issues that potentially could lead to claims against conveyancers undertaking residential leasehold transactions. So, Robert, I hope you don't mind if you could sort of join me for a moment or two and share with us what sort of products does Stewart Title have available that practitioners may not be aware of that fit the bill, as it were, with regard to residential leasehold potential claims against conveyancers?
Yeah, well, Ian, it's funny, when you were just going through those points, there were a number of them that struck a bell with me. One of the main things we get asked for is really what we would describe as missing title information. And that's where things are described in the lease by reference to a plan, and a copy of the plan can't be found. Very common in city centre developments where car parking is not in the same building or is outside the main demise. Our normal course is to say to people, go to the land registry and get a full copy. And many times we get told that actually it is the land registry copy they've got. So there are, I think the worst we've ever seen is a lease which was obviously double-sided, where the land registry actually only photocopied every other page.
Yeah, I've seen that.
And normally they're fine with plan one, the demise, but when you start getting, as you were saying there, defining car parking spaces and rights, but as easements or as separate demises, there'll be a plan two, and I'm not so certain the land registry check that. So we would offer there missing title information where you simply can't understand the rights because of lack of a plan. That goes even into things like service charges, where sometimes the calculation page is missing from a lease. And in both those cases, particularly service charge, whilst you could probably apply to the landlord for a copy, that might be the last thing you want to do. So there are areas there. And again, on demises, you'll quite often find when you're buying a lease that there's a neat red box showing the demise, but it doesn't include things like balconies or outside terraces and so on. So again, there we can issue policies, and at that stage, people might want to think about, is there an overhang problem over a public highway, which is quite common in the sort of city centre developments. So we can issue policies there, and then down to more basic ones where you can't find the landlord. We can offer missing landlord policies to deal with lack of consents, lack of receipts for ground rent, and things like that. So practical ones there that I think can help you avoid negligence or make a lease better for your client than it is when it's offered.
Right. Okay, that's useful. That's really, and all that information, Robert, relating to those, is that all available on your website, or do people have to?
Those are all available online on Stewart Solutions, so they can be downloaded there. But obviously, in some cases, people may want to talk to the underwriters about it, but they are there for you to deal with.
Fantastic. Thank you for that, Robert. Thanks for your comments and for the information. It's useful. Negligence claims. Again, my mantra, do the simple things well. Read the lease, make sure it's a complete lease. I was laughing when Robert was saying about the land registry, copy the lease and missed every sort of even page. I've seen a claim where a firm of lawyers drafted a lease, sent it out to their client for the client to have a look at it before he went off to some leaseholders, and it was sent out to the client double-sided, but then printed off and sent to the prospective tenant solicitors single-sided with every even page missing, and it was approved. So how on earth did that happen? Who knows? I've also seen a lease being sent out where the lease and counterpart weren't the same. I've also seen a situation on a leasehold transaction where a draft contract was sent out with a draft lease annexed, and then at completion, the lease that was executed by the leaseholder bore no relation to the draft lease that was annexed to the contract and that the lawyer had reported on to the client. That was quite an interesting one. Checking superior title. If the superior title is registered, not a problem. If it's not registered, we need to see it. Remember what I said to you in the past with regard to land registration. Sometimes an absolute leasehold title granted post-June 2006 is not a good and marketable title because the superior title required landlord's consent or mortgagee's consent, and that consent was not available for the land registry. They've granted an absolute title, but put a warning in the property register that a consent was required that they haven't seen. The term. A lot of people get excited about this, and you'll see lenders will say, well, as long as there's more than 25 years remaining after the mortgage comes to an end, we're happy. And you'll see conveyancers that will say, as long as the term exceeds 60 years, then we're quite happy with that. My advice is, any lease term remaining of less than 90 years, you warn your client. Where you're with a lease term of less than 82 years, there are significant issues with regard to enfranchising or extending. There is on the Leasehold Advisory Service website a sort of calculator as to the amount of premium that can be paid. It's not that sophisticated, but will give you an idea as to just what is required to be paid where a lease extension is required. Identifying the demise we've looked at, rights, exceptions and reservations in the lease, what are they and how do they work? Ground rent we're going to be exploring, I think it's next week to be honest with you, so we can talk in detail about that and have a look at it, but certainly we can have a ground rent provision with a ground rent review, but my stance here is that we need to be able to determine what the likely conclusion of that review will be. Unusual clauses in the lease, particularly shared ownership leases, watch out for. Are there mutually enforceable repairing covenants? If there are deeds of variation, are those deeds of variation effective? I dealt with a lovely negligence claim. That's horrible, isn't it? There's no such thing as a lovely negligence claim. But I dealt with a negligence claim where a firm of lawyers realized that the lease was defective, required a deed of variation from the seller's conveyancer. The lease was varied, but the variation didn't remedy the defect and in fact created another one. Buyer's conveyancer just ticked a box to say, yeah, he'd seen a deed of variation, but then acquired, in essence, two problems rather than thinking that he'd resolved one of them. Service charge we've covered off and we've talked about. Management companies. Does the management company exist? Is the management company properly run? I deal with a lovely management company in Leeds, and it's run by two sort of retired school teachers who are absolute delight to deal with. They're very well organized, they have regular board meetings, and they deal with everything that's necessary in a perfectly proper manner. I wish all management companies were run in the same vein. The only funny thing about these two is whenever there's a dispute with regard to leaseholders, they tend to hide and go on holiday, in the hope that by the time they get back from the holiday, the parties have managed to achieve some form of accommodation between themselves. But lots of management companies are not well run. Lender's Handbook requires us to ascertain that the company exists, so company search, and that it is well run. Well, how do you do that? I normally ask for the minutes of the last board meeting of the management company to see that they have met and see what they've discussed. And I kid you not, I once saw some board meeting minutes that were taken up in the main by the company secretary producing to the meeting some wedding photographs. And there was a discussion about that lovely event, all carefully minuted, next to nothing about managing the block or issues relating to management. Forfeiture. We can have forfeiture provisions in residential leases. Important, however, that the lease cannot be forfeited due to tenant insolvency. Residential leases are being forfeited. They are forfeited on the basis that the service charge or rental is outstanding, a money claim is brought by the landlord, a judgment is obtained by default, and then forfeiture proceedings begun. Entirely contrary to the spirit of legislation that requires a court order or a determination that the tenant is in fact in breach of covenant. Insurance provisions, again, specialist advice might be required relating to provisions. Covenants and regulations we've discussed, repair we've discussed. What does the client need to know? We can't select from a lease key features that I think the client should know and other issues that the client doesn't need to know. I think we've got to make sure that we translate each and every provision within the lease. So when we talk about what the client needs to be informed about, I would always say, well, what would you want to know with regard to your lease? I've talked about lenders and leases, again, issues with regard to term, forfeiture, ground rent and ground rent reviews. Uncumbersome ground rent reviews can cause issues with regard to lender valuations. We'll talk more about that a little later. And as I mentioned, do watch assignments of unregistered leases. In the notes, I'm conscious of time. I've referred to the new Help to Buy scheme, which is going live in April 21. In these new schemes, ground rent has to be peppercorn, requirement for energy efficiency compliance, and an adjudication scheme managed by the new Home Ombudsman is required. The scheme isn't operational yet, but will be by the time the April 21 comes along. Requirements for builders to disclose their Home Builders Federation star rating, again detailed in the notes. Airbnbs, I talked about client objective. A breach of user covenant is likely to apply if our client is letting out for Airbnb purposes where there is a private residence covenant on the basis that the case law suggests a private residence covenant is inconsistent with short-term tenancies or any form of tenancy that lacks sufficient permanency. Breach of covenant would constitute a business activity that wouldn't be private residential is another case. And finally, there's some case law there that suggests that if there is a breach of covenant by a subtenant who then sublets, that the wording of most user covenants would catch such a subletting, but you need to check the wording of the lease. The case that I've given you that's relevant relating to that is the case of Bevan House Management, that's in the notes. I'm conscious of time for everyone. I want to talk now about restrictions and leases. Remember, a restriction has to protect an interest in land. It must be capable of being complied with, and it must protect a disposition or registration. September 2019, the Land Registry slapped our wrists and said restrictions should not be used to protect dispositions, but should be used to protect registration. They've now gone back on that stance and said that a restriction can protect a disposition. Key point there, make sure you define what a disposition is in the lease and make sure, as far as restrictions are concerned, they are capable of being complied with. In the notes, I've shown if a landlord no longer exists or doesn't comply with a restriction, or a management company doesn't exist or isn't complying with a restriction, the Land Registry will be receptive to disapplication, cancellation and modification applications, which we spoke about on our last discussion of land registration issues in a previous webinar. The Land Registry will always suggest that restrictions are withdrawn. For a restriction to be withdrawn, it is necessary for the restrictioner to consent. Disapplication, the restriction is disapplied for the current disposition, cancellation or modification, the restriction is modified or altered forever. Before I finish, Robert, are there any other products from Stewart Title that you think practitioners need to be aware of in view of some of the comments that we've made today? Or are there sort of products that are significant that perhaps people will be comfortable with in a freehold context that might have a bearing in connection with a leasehold context?
Yeah, I mean, I think there's certainly, it's sometimes, particularly when you're dealing with the residue of a lease, to think, is it necessary to do searches and inquiries and so on? So if you have that doubt because of timing and or cost, title insurance and no search insurance might be a remedy there. But there were a couple of points that we've just been talking about that just made me think of alarm bells for lawyers to think about. Again, with a residue of a lease, don't forget that the majority of policies talk about market value, and it may well be that the leasehold market value is not that great. So consider what you want to cover or what your client wants to cover. But actually more concerned about double rent if they have to find alternative accommodation, or moving costs and things like that. So again, always speak to the insurer to make sure you are covering what you want, because a straightforward market value may have very little protection to your client. And when you were talking about changes in use and layout and so on, obviously they're probably done with the consent of the landlord. Don't forget that if you are buying a property which has the benefit of existing title insurance, changes like that should be notified to the insurer. Yes, changes in the layout may actually make possibility of a claim greater, and a change in use maybe if you're looking at restricted covenants affecting both the freehold and the leasehold. So again, it's always the danger of overloading clients with information, but it is something to consider if you're acting on any deed of variation, that it may affect and potentially void existing insurance.
I hadn't thought of that, Robert. That's a great point. Yeah, thank you for that. Brilliant.
Robert, Steve, following on from that, actually, we have a question that I think it links in quite nicely. So Zara has asked, would you recommend a contingent buildings insurance policy on every leasehold purchase? 9 out of 10 of the landlord cannot give individual reinstatement value per flat, so we don't know if there will be a shortfall between the mortgage and the reinstatement value. I don't know if you have any thoughts on that, Robert. Sorry, are you there?
Right, so yes, it certainly might be belt and braces, but it is there, and it's a matter really of the cost to your client, I suppose, isn't it? And weighing up that risk, but it's got to be a possible danger there.
Yeah, I think if you've got a risk-averse client, it's certainly something worth mentioning. And I know some firms mention it to all clients. You know, at the end of the day, it's the client's call whether they want that protection, but I think it's your responsibility to highlight it. So it's a good point, yeah.
Excellent. Thanks both. Yeah, I agree that I think the cost is a consideration in terms of the client as well. So. Ian, sorry, back over to yourself.
Stephen?
Yes, hi.
Hi, are there any other questions?
There are a few. Are you ready to move to questions, Ian?
Take some questions. Yeah. Have you got a poll? Do you want to do that now, or do you want to do and do questions afterwards, or how would you like to work that?
We can run the poll. So yeah, thanks everyone for staying on. So as I said previously, we've been really happy with how the webinars have been going, but we're also using this lockdown period to look at all aspects of our business and try and improve everything where we can. And obviously we do that anyway, but I think it's a good opportunity to pause and reflect on where our strengths and weaknesses are. What I think we'd like to know from you is, in terms of when you're looking to choose a legal indemnity provider, what is your most important consideration? I'll run that poll now. Unfortunately, there's only one choice, so it really is your most important. I'm sure that all aspects of this are important to you, so I'll just leave that running for a moment there.
That's fine. So Stephen, while people are doing that, are there any questions you can fire at me so we can?
Yes. So we have a question from Amina. Amina asks, if the office copy entries of an underlease state the land registry have not seen a copy of the consent of the superior landlord, what do we do in that situation?
Right. Well, the title is likely still to be an absolute title. You should you either make inquiries of the superior title to obtain the consent, or you warn client and lender that the absolute leasehold title is vulnerable either to mortgagee possession or forfeiture by superior landlord. I don't know, Robert and Steve, do you have a product for that? It's an absolute leasehold title that potentially is not good and marketable on the basis that there's a warning in the property register that there's a lack of consent relating to the superior title out of which the lease is derived.
We don't have a product specifically for that, Ian, I don't think. I mean, I will be overall by Robert, but I don't think we cover that situation.
I think we might be able to look at it again as a missing title information one, but it would be on a bespoke basis. And we'd certainly need to know what investigation's been done. So I think theoretically it's possible, but it would be more complicated than normal.
Yeah, to be fair to everyone, it's not something you're going to encounter every day, which is why it causes negligence claims. What you do is you look and you think, oh, this is an absolute leasehold title, that's fine. Buried in the property register is this warning that the land registry hasn't seen the consent, and that generates the vulnerability for the leasehold title. So great question, which I hope I've answered there. And again, in a situation such as that, you can either attempt to perfect the problem or alternatively contact Stewart Title for a sort of bespoke policy.
Excellent, thank you. So we have a question from Moats Gambler, who I hope is still on the line. I've been waiting for this opportunity to try this, so and it might have taken a bit of arm wringing on behalf of myself, but I'm going to try and put Moats over the speaker to ask the question directly, if that's okay, Ian.
Hi, Stephen. It's actually Robert McNally. But no, don't worry, Ian. Thanks for taking the question. It was really a question. Lawyers these days and there are happening quite a lot of developments of old office buildings under PDR, under the PDR scheme.
Yeah.
And really, it touches on a number of things you've raised, but. I just wondered whether you had a view on the bona fides or the legitimacy of a developer converting a 30, 40-year-old office building, probably built in the 70s, into residential flats for sale, where he then grants a 125-year lease, sells it off to an unsuspecting tenant, and how what your views would be on how a lawyer should properly be advising that purchaser as to his potential financial liabilities under service charge for what could be potentially very heavy repair costs in respect to that building as it comes forward.
Well, we're back to this issue. It's a great question. We're back to this issue about survey. I always say to any leasehold buyer, there's a need for a full structural survey of the building. Now, the client isn't going to bother with that because he's not going to afford it. He's not going to be interested in it. But
that's the point.
You've got that refurb or that revite, and you've got a 70s construction, alarm bells are ringing. And I warn clients. I also would provide clients with scare stories. So, for example, I think it's one of the buildings at not Canary Wharf, the Barbican. There was a 70s building there, and there was a requirement for new windows, and the cost of replacement was absolutely astronomical, such that a lot of leaseholders in that block couldn't afford the service charge and were having to sell their flats. So, there was an example of a 70s refurb, not necessarily a bad building, to be honest with you, but huge sort of latent issues relating to construction that come back and bite the current leaseholders. So all you can do is just say to the client, look, given the building, given the history, given what the lease is saying relating to service charge, we need a surveyor not only to look at the demise, but also to look at the building. And really, to do the job properly, we need a structural survey relating to it. And say to the client, that's what my advice is. I mentioned the RICS consumer guide with regard to surveys. Say to the client, look at that. If you're going to get a valuation or a relatively traditional survey for this lease, that's not necessarily going to highlight or generate the potential issues that could exist. The other point, the other way of dealing with it is to look at warranties, etc., from developers. But again, on these schemes that I've seen, what the developer does is create an SPV that basically acts as landlord. So any warranties aren't really worth much on the basis that the SPV doesn't have a particularly a great amount of credibility or a strong balance sheet to meet any claim.
I agree, and I do wonder whether we've seen problems with cladding and following Grenfell. I'm just wondering whether there's a sufficient awareness perhaps of the potential issues that these PDR right conversions actually give rise to.
Yeah, and I mean, you know, at the end of the day, it's the it's the client's call. Luckily, you know, in a situation like that, which is really a traditional leasehold purchase, it's you're pointing out the potential risks and vulnerability, and it's the client's call. You know, we were talking about conveyancing in lockdown. The problem there was what we had were extraordinary situations, and therefore all clients being inexperienced, and therefore being required to sort of really hold our client's hand with regard to the process. I'm just thinking that with regard to conversions of office blocks, again, they're not traditional sort of leasehold purchases. So perhaps, again, there's a requirement to hold the client's hand more than usual. But when I talk about holding the client's hand, what I'm saying there is just warning the client about their potential vulnerability. You've touched on cladding. There are other issues related to construction, aren't there, with regard to office blocks that are bound to generate problems in the future.
Exactly.
Yeah, so great question. Thank you.
Ian, thank you.
No problem.
Yes, thank you, Rob. Thanks for that, and thanks, Ian. Ian, I'm quite conscious of time, so I'll do one more question for now. In terms of questions we've asked, we've had lots through the series. I think what we are looking to do is put all of these together in a document and try and come back to all of them. So there is a reference point there for all the questions that have been asked. Ian, if I made those, we have just one question from Farhan, and they say, hello, sorry this has already been mentioned, but I was wondering about the sweeping up clauses which you mentioned. They're so vague in nature. To what extent or what examples of costs do you believe could be included or excluded from them? And then follows on and says, and how can we advise the client against what charges these may include?
Yeah. Well, a sort of general sweeping up provision without providing examples of what the clause is meant to catch is potentially unenforceable. So what we're looking for is a general sweeping up provision and then a list of the sorts of expenses that are likely to be recovered. In doing that, if there are items outside the list, then they're potentially caught by the sweeping up provision. But just to say, leaseholders are liable by way of service charge for all or any expenses that are reasonably incurred in connection with the management of this building, that clause is probably unenforceable. Okay, so what you're advising a client, if you're advising a leaseholder, you're saying to a leaseholder, look, the lease contains sweeping up provision. It is vague and ambiguous as to the extent of what can be recovered and therefore has the potential to be charged. But subject to that challenge, as currently drafted, you're liable for any expense that the landlord incurs, subject to what the wording of the sweeping up provision. So again, what we've got to do is just set realistic client expectation. Hey, potentially we can challenge it, but until it is challenged, you're potentially on the hook for any reasonable expense that the landlord incurs, is the way I would deal with that issue. Is that okay, Steve?
Yes, it is. Yeah, thank you. Thanks for the question as well. So I think we'll wrap up there. Yeah, thank you for everyone that's stayed online today. Ian, thanks again for a fantastic presentation. Already some very good feedback. Yes.
Have you got any magic tricks for next week?
No magic tricks.
With regard, without getting someone online and speaking rather than questions, we're going to have some other sort of.
You never know what I'm going to throw at you, Ian. That's the thing.
That's good. Okay, look forward to it. All right, thanks very much, everyone. Thanks, Steve.
Thanks, everyone. Appreciate your time. See you again soon now. Bye-bye.